Can you start your video and unmute yourself, please? Calling the case number of SP 4519123. This is the state of Michigan versus Mina Jenna Conley. Your appearance, please. That means tell me your name, ma'am.
Manaya Janae Conley.
Okay, and this is the date and time set for an informal hearing. It was set for 9:31. It's now 9:49. The officer has failed to appear. Therefore, this matter will be dismissed without prejudice. Any objection?
No.
Okay, but before that, ma'am, it's just not always going to be that easy because I would like to note two things. You're driving at a disgusting rate in a construction zone. You are putting your life and that of construction workers in danger, driving your car in such a manner. Okay? When I read this remark that says you are going 81 in a construction zone, that sends me. Okay? There is no reason in life, and you are not that important, for you to be driving so recklessly and selfishly on the road. And then I look at the ticket and the trooper gave you a deal and wrote you a ticket for 5 over, which was a gift, right?
Right.
Because 81 in a construction zone, certainly if I do the math, is not 5 miles over the speed limit. And instead of taking responsibility for that and taking the loss and taking the break from the officer, you requested an informal hearing on it. And the break for you today is the trooper did not appear, so the ticket will be dismissed. But all that shows me, the court, is the type of person and driver you are. That you would drive in a construction zone where there are workers. Don't roll your eyes at me. Don't roll your eyes at me. And get a break at the road from the trooper. And instead of being gracious and responsible, you pushed for even more consideration. And you get that break today on a technicality because the trooper didn't appear. But you better think long and hard about yourself. If you roll your eyes again, I'm going to set this for another hearing.
I'm looking up. I'm looking in the background. Never roll.
Okay, well, I would like you to look at me. There's no reason to be looking up.
Okay.
Show some respect and stop being such a selfish driver. And if you can't handle the responsibility of driving and the workers on the road, do everyone a favor and hang up the keys. Those men and women working out there are risking their lives. And the fact that you got such a break on the road and pushed it for a hearing today shows me that you think there are no consequences to your actions and you should just be excused for your selfish behavior. Learn that you exist with other people in this community and you are not important. You are not important enough to be driving and disregarding the other people and workers on the road. It is not about you. Slow down, be aware, and if you cannot be responsible enough, then don't drive because it's a privilege. Are we clear?
Yes.
Okay, you may leave the Zoom.
Buckle up, guys. Today we're diving into 3 wild courtroom moments. A reckless driver facing a furious judge, a bond hearing that goes off the rails, and a sovereign citizen trying to outsmart the law. But first, the host sets the stage, mixing insight with humor before rolling straight into the first hearing. It's the calm before the storm, but trust me, every second after this gets a whole lot louder.
Thank you and welcome back. So we're going to begin in case number 25-4703FY. Mr. Ullman is appearing for arraignment in the underlying charges. He had one failure to appear, but we had renoticed that, so he's not facing any issues with regard to a failure to appear for the arraignment in this case, just the bond violation issues.
Okay.
And arraignment in the underlying charges. So Ms. Ferrara-Wilbur, did you have opportunity to review the allegations on the felony complaint, nature of the offense, possible maximum penalties, as well as the issues with regard to the bond violations with Mr. Ullman?
Yes, thank you, Magistrate. We did have the opportunity to review the complaint and the alleged bond violations, as well as Mr. Ulam's rights in this matter. In regards to the underlying charges, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel. In regards to the bond violation, he also waives a formal reading, pleads not guilty, and requests that it's set for a hearing with counsel.
So I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. Ms. Ferrara-Wilbur, is there information you'd like me to know regarding bond?
Yes, thank you, Magistrate. In this matter, we would request that the bond is reinstated. On May 28th, it was set at $25,000, 10%. As Mr. Ulam stated, he does part-time handyman work. He's currently homeless and has no access to funds for a bond, but he has taken steps to obtain a mailing address and has access to a phone to maintain contact with the court and counsel in this matter. Thank you.
Well, at one point, he had posted the bond through bonding agency. So he had been out, and thus the reason for the allegations on the bond violation. And with regard to that, Mr. Ulam, I am going to remand you to jail until the time of that hearing. So the bond that you did have is gone. You are no longer on bond. You'll be remanded again until the time of the hearing. We'll get that scheduled as quickly as possible. You should hear from your court-appointed attorney by the end of next week, and we'll make sure that the hearing is expedited.
All right, here we go. The first courtroom clip kicks off with a twist. The officer doesn't show up, so the case gets dismissed. But just when the defendant thinks she's off easy, the judge flips the tone, calling out her reckless 81 miles per hour speeding in a construction zone. You can feel the tension rise as the judge's patience fades, and her words cut sharper with each second. Justice might be lenient, but it's not blind.
We'll move on to case number 25-4779SM. And Ms. Ferrara-Wilbur, you had opportunity to review the allegations in this complaint, nature of the offense, and possible maximum penalties with Mr. Ulam as well.
Yes, that's correct. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel.
Based on the information that you've provided, I will appoint an attorney for you in this case as well. The next step in the process is a pre-trial conference. In this case, the pre-trial conference would be scheduled for July 15th. It would be at 9:30 a.m. And again, Ms. Ferrara-Wilbur, information regarding bond.
Thank you, Magistrate. Based on the remand in the other matter, we would request a low cash bond in this matter.
So your bond in this case is going to be a $10,000, 10% bond. Conditions on this bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You would have an immediate urine screen and twice, we'll say 8 times per month, urine screens hereafter. You'll have no contact in any manner whatsoever with Darcy. Means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with her. You will stay 500 yards or more away from her. You may not be at any address that she is or may be. Specifically, you may not return to 811 Linwood Lane. You may not use nor possess any.
No,
Excuse
Mr.
me,
Ulam, no, Mr. Ulam, no.
What address?
Mr.
What address
Ulam,
again? What address? I'm just confused. I just wanted to repeat I want to understand what the address was. What was the address?
The allegations in this complaint allege that it was at the residence at 811 Linwood Lane, but you
Okay,
can't be
okay.
at any address that Darcy Robinson is or may be. You may not be within 500 yards of her
I get it.
workplace or any
I understand. No,
address.
I get it. I just want to clarify that I can't go to my home. I can't go to my house. I get it.
Mr. Ulam.
I'm homeless. I can't go to my house. Thank you. That's good. Thank you. Just making it clear that I'm not allowed to go to my home. Thank you very much.
You may not use or possess any weapons of any sort. You'll have no threatening, intimidating.
I know what the last ones were. Thanks a lot. What are you talking about? Oh, man. You took my phone. Hey, tell Darcy Robinson not to bomb me out again, too. She bombed me out last time. Tell her not to bomb me out. Hey, come on.
So the words that I'm speaking about the no contact are in effect immediately, Mr. Ulam, and it's going to be a $25,000, 10%.
Now comes the explosion. The judge lays into the driver, delivering one of the most brutal reality checks caught on camera. Every line drips with authority as she reminds the woman she's not that important, and that driving is a privilege, not a right. The energy in the courtroom is electric. Embarrassment, guilt, and moral fury collide in under 3 minutes. It's the definition of tough love in action.
All right, parties. I'm gonna figure out, and then we'll determine whether or not how we're gonna proceed. How we're gonna continue on. So I need both of you to unmute for me.
Yes, sir.
All right. Both of you raise your right hand for me. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
I do.
So let me first get a little bit of basic information. So Trust Property Services, do you guys have is this a commercial or residential?
This is a residential property.
All right, great. And when was the lease entered into?
March 25th, 2019.
Okay, when was it last renewed?
It was renewed on, it was signed on March the 9th, 2022.
Okay, and has it just been renewing every month since then?
Yes,
I mean,
sir.
every year on the other.
Yeah. Every,
Okay. All right. So technically renewed again on March 2025, but I understand that there's allegations of default before then. So how much is monthly rent?
$1,750.
Okay. Is there a late fee? If so, how much?
There is a late fee, Your Honor. The lost discount is $100, and then there is a $10 per day additional rent, but I understand you have it capped at 10%.
Yeah, so we can do it at 175, which would be the most. When's the last time the tenant paid rent from any source?
That was on the ledger there. It was February 25th, 2022.
That's the last time he paid any rent?
Excuse me. No, sorry. That was when he started paying rent again. So previously he got behind significantly, and the county stepped in and
Objection,
paid.
Your Honor.
Oh, okay, well, he can tell me what he wants to say. Overrule. Continue.
Okay.
Okay.
And March 25th, 2023 was the last time rent was paid. So we began accruing rent at April 25th, 2023.
Okay, well, your complaint doesn't ask for all of that. It says that it is from December 25th, 2024 through March 2025. So explain that to me.
I did not file it myself. My assistant has been in the hospital 4 times, and some weeks at a time, so I'm not sure what was filed.
Well, that's a concern because you're pursuing this and you got that this was filed back on, this was filed April 8th or April 18th. So this is well after that. Well, for an opportunity for you guys to make any additional determinations. I just want to make sure we have some clear numbers because the numbers that you're asking for in the complaint that was past due in April, $10,000, that was for rent through March.
Could you state, I'm sorry, sir, could you state that amount again? The thing went in and out.
Past due rent of $7,000, and that's for the months of December 25th through March 25th, 2025.
Yes, sir.
Okay, so I just want to make sure that you're aware of that. I understand that you're the agent, but so he hasn't paid rent, at least according to the complaint since then, and you guys have not received any monies since December or since November at all, or at least in some.
That's correct, Your Honor. Not that I'm aware of.
Okay. All right. Well, just hold tight. Let me speak to Mr. Stevenson. So, Mr.
Yes, sir.
Stevenson,
What's going
when did the initial lease get signed? You recall?
on? Yes, sir. It was signed probably in I want to say 2019 or 2020.
Okay. When's the last time you signed a lease?
The last lease I signed was probably in 2022.
Okay.
I would like to say that I'm perfectly fine with answering all your questions, Judge. Nothing. I've filed a lot of evidence in this case showing that they have not done their due diligence whatsoever in this proceeding, which you've already recognized to a degree with their misnumbering of their own numbers. But I don't. I'm challenging the jurisdiction of the court. I don't believe this belongs in this court. I reserve all my rights, and I do not consent to administrative process and without equity, according to Article 3, oversight.
Next up, the scene shifts to Michigan for a new defendant facing a bond violation and a fresh felony charge. The tone is cooler at first. The magistrate, defense, and attorney move through the formalities. But beneath that calm lies tension, as you can sense something's about to snap. It's the classic setup to a courtroom meltdown, the kind that starts quiet and ends in total chaos.
With due process under law, because I have a lot of evidence showing that I did my due process and did not receive that from them. Basically, that $7,000. He's saying that they just submitted a ledger to you guys saying that $65,000 is owed. And saying
I haven't seen that ledger.
but
So
he just said it in mediation. I'm not assuming.
So just hold tight.
Yes, sir. I'm just saying I got a lot of stuff, and it's a real case.
Oh, and then we, if need be, I can get into all of that because right now,
Yes, sir.
one, what you discussed in mediation, I'm not aware of, right?
Yes, sir.
So I all of that. That's why I like to ask my questions, and
Yes,
then
sir. I just wanted to make sure I got on record that I do challenge that we should even be in this court.
And I would say, if that's the case, did you file a?
I will.
But you haven't. So you have not sought to have the case removed to federal court, have you?
Not the federal yet. I was trying to get it removed, just the superior.
Okay, and under what basis?
Under the basis of equity. This is a rent-to-own case. This is not a normal tenant-landlord situation.
I would pause you because I'm very familiar with that. And if it's a rent-to-own situation, those generally are still considered contracts. You may have a lease, otherwise. And so, just before we get into that,
okay,
because I've been doing this a little while. So,
I'm with you.
All right. So tell me, is rent $1,750?
Your Honor, I'm not aware of what the rent is currently.
Well, you told me that you signed a contract back in 2020.
The contract that I signed, the rent was not. If you review,
oh, how much is it? How much is
the rent that I signed at the time? The contract was $1,450.
Okay, $1,450.
It was $1,450.
Just getting information.
Yes, sir. Okay. I'm with you.
Did you submit your last contract online? Did you submit it as part of your evidence?
The contract, no, neither one of us submitted the last contract signed. I can't produce it, but I did not submit the last.
So hold on. Let me do my job. Okay.
My bad.
So you're saying the last rent is $1,450. Was there a late fee associated with that $1,450?
I believe so.
Okay. And let's just say for giggles, because we only gonna give him 10%, there was $145. Right. So tell me this. When is the last time you paid rent? Or anybody on your behalf?
I believe the last time that I paid rent would have been in the year of 2023, December of 2023 or so.
And there it is, The bond gets revoked. The magistrate's decision lands like a hammer. The defendant loses his $25,000 bond and is immediately remanded to jail. The look on his face says it all: disbelief, anger, maybe regret. You can almost hear the moment he realizes his freedom just vanished. The calm before has cracked wide open, and what follows takes it to the next level.
I get all right. Equity in this home. Neither one of you have submitted a contract. So tell me what
I didn't file a complaint.
but you're having a defense that you have
I do have
equity
a
and
defense.
rights in this property, right? So
'Cause
it's
they
your
left me alone.
responsibility. So listen, it's your responsibility to put up all the necessary defenses to support you, right? And so what I'm saying is, you're saying you have a special kind of lease. So tell me what parts of your lease, since I don't have the lease here with me, justifies it. Well, hold on. I
okay,
guess
well-
Mr. Brown was going to answer that. Do you,
Oh,
Mr.
well,
Brown, does he have
I thought you was, okay.
okay. Do you?
I'm fine. I'm quiet. I ain't said nothing, man. I'm good. I thought you was talking to me, so I thought I was.
I was. I'm sorry, but you were just going. I just want to know what part of the contract. How do you have it? You have a lease to own? Is that what you have?
It is a rent to own. It is a rent to own where you're only supposed to be in it 3 years, and then you either basically leave or you're in a ownership position. I have to do my own maintenance. There's no. That's not me. That's coming out from my side. There's no. They don't come do a bunch of maintenance. I have to fix my own back porch. I got to do. You know what I'm saying? So what I was asking for a year ago when they came to me saying, "Hey, you owe some money," I felt like the accounting was off, and so I asked to see the accountant. They refused to show the accountant. That's it.
All right, Mr. Brown.
Yes, sir.
A lease to own agreement.
I'm just looking back. It would have been long expired if there was one. I'm just looking back right now because we do have a rent to own opportunity, and we do help deserving families end up with home ownership regardless of credit or financial background. So we work that into our program, and we give people up to 3 years to buy. And so when he signed in 2019, that would have been expired by now. And I'm just looking back to see if he even did that.
I'm not going to further delay this. This is what I'm going to do. I'll be honest with you, Mr. Stevenson. The initial facts, and because of the history I have with these cases, I would argue that they would be entitled to a writ. Particularly the amount that they're seeking is a lot less than what you would normally be paid because of. But guess what I don't have? I don't have a contract. And you make an argument that you may very well be entitled, but I don't have it. And depending upon the language of that contract will really make a determination of how I proceed. And so I'm going to reset it for in person. I don't necessarily believe that there's a basis for it to be in Superior Court. Those issues based on the contract may reveal that that's not necessary, particularly if you're not alleging that you've paid all this time or have submitted to them a opportunity to purchase and they didn't accept it. That's a different. But just saying that you have a lease to own, but then you've defaulted on it and you're very well entitled somehow to some type of equity. You might be entitled in a separate action and maybe some of the improvements that you've made, but that may not prevent them from being able to get you evicted. And that's a fact. That's
Your
a
Honor,
fact.
can I ask a question?
Sure.
Okay, so the fact that I still have a UCC claim, 100%, they did not respond to my request for. I have a right to accounting. They blocked it. What about the
But
fact
that may
they-
not prevent me from dealing with possession. See, I think you misunderstand.
Oh no, I'm not saying. I get that. That's what this is dispossessory court. I get
Yes,
that's why I asked to have it removed to a higher court. What I'm
But
saying
you
is,
need to file that stuff.
well,
Superior Court
I
is
will
not federal
file
court.
it because I don't want to be put through this administrative process, which this basically is, and it's just kind of a quick kind of will and deal thing. And he's got legitimate. I have legitimate things that I'm saying. I asked for accounting for debt, and then now for them to submit a debt of $65,000. So what you're telling me is we're going to come to meet you, and we're just going to discuss the $6,500 and not the $63,000 that they're trying to put on the ledger now.
Well, I'm going to be honest with you. If you ain't paid rent in a year and a half, that wouldn't necessarily sound like that's not reasonable.
But under
Are
the
you
law,
on the property
under
right
the law,
now?
though, I have a right to nullify that debt, and they didn't request that debt.
Here's where everything goes off the rails. During his second hearing, the defendant can't control his frustration. He interrupts, argues about the address, and finally snaps, hurling insults as the magistrate stays composed. Within seconds, his bond doubles to $25,000. It's a perfect display of how one emotional outburst can turn a bad day into a disastrous live, unfiltered courtroom drama at its peak.
All right.
I'm
I'm just.
gonna reset the case. You're not even gonna have to
Okay.
worry about an appeal because I'm not gonna do an order today. I'm gonna reset the case, and someone's going to submit to me the copy of the contract, and then we can take a look.
Your
Mr.
Honor,
Brown.
I did submit the contract. If you'll look at the
Oh.
email that we did send both the contract and the extension.
Clark, can I it's not in my file. Or maybe it's in documents and not in exhibits. Hold tight. I see that. All right.
It
I don't
was sent
see-
to dispossessory,
when
seat
did you send it?
court 2. Let me see here, so I can be correct. Dispossessory CT2. I can't see the full extension of
Clark, do you
the,
have an email from Mr. Brown?
I'm looking. Sorry.
thank you. It would have been from Judy Weaver, my assistant.
And Mr. Stevenson, just so you're aware, if you're alleging federal matters, that isn't necessarily a Superior Court issue. That's a federal court issue. So having it removed or transferred to Superior Court still wouldn't be the appropriate place. Just to
It may be a federal thing. I'm just saying that I asked for the accounting of all of this so that I could pay and do my due diligence. They failed to do that and then didn't request any money for a year. And then they just showed up.
And Mr. Stevenson, while we're waiting to see whether or not that's the case, what due diligence were you trying to exercise in a rental agreement? Was it a situation where they weren't
It was a situation where I did not agree with what they were saying was owed by me at the time. They were saying I owed more money than I agreed with. So I filed a form saying, show me the full, because we've been in business, like he brought up, during COVID. And just for the record, I just lost my mother on Easter, right? So
I'm sorry about that, brother.
I'm just saying, because he was mentioning, he mentioned that the clerk who filed all this stuff improperly has been in and out of the hospital. I've been through with breast cancer for the last 3 years. What I'm saying is my due diligence was still done properly, and theirs was not. And I feel like the court has to honor the fact that you have to do business the proper way. And so that's my stance, is that I asked for them to do business properly. They did not do it properly. They did not say anything. They left me alone for a year. No mail, no correspondence, no nothing. And then show back up and requested $6,500 for the new year, not 2024.
All right, hold. So the original one, this is 2019. It's a standard real estate rental agreement.
Mm-hmm.
I'm gonna share this thing with you.
No, I know it's a lot in there. It's towards the bottom where they get into the rent to own stuff. You come to classes.
Hold up. I got you. Hold tight. All right. So at this time, can you see what I see?
Yes, sir.
All right. So I'm gonna scroll on down. You tell me what section is the rent to own.
Okay.
And either one of you guys go ahead and jump in and tell me.
No part of that agreement refers to rent to own.
This isn't the full.
Okay.
This isn't This doesn't have anything mentioned about the other part of the program that they have, which is the path to home ownership. That's it also in the agreements.
All right. So there's a path home ownership.
Path to home ownership is what it's called. It's not listed. They're not showing that in that document they submitted.
Now for the third case. A landlord finally faces a tenant who hasn't paid rent in 18 months. The judge calmly breaks down every late payment and missed month. And you can feel the buildup, the tension of polite courtroom order before it erupts. Each answer from the landlord exposes how deep the issue goes. It's quiet, factual, and yet you know the real fireworks are just seconds away.
So
I'm looking.
Okay, I was going to answer you, sir. Okay, you want me to answer? You want me? I can answer.
Yes. No, please.
Okay. Based off of my understanding of my legal rights, I understood that if they do not produce, and from what I saw in the UCC, if they do not produce the accounting properly for the debt does not. They are basically forfeiting the debt. And so I was like, oh, then we good. Y'all don't want to take or receive my stuff.
But you don't have. I think that's the part that you're missing, and I just want to be clear. You don't like the debt that you may be. This isn't a mortgage. This isn't, and I understand you're saying you had an option to buy, and I guess I'm missing that. But ultimately, your option to buy might get eliminated because you have a rental agreement that essentially, when you default on that agreement, that almost extinguishes some of your rights. And so I'm really
But I
not trying
didn't
to be
default on my
difficult with
rent.
you, but you did. You did default, and you
But
defaulted
no,
based on your
Your
own
Honor,
admission.
they have produced no accounting. And this is why we definitely need to come in person. They
But
have
you've
produced no,
admitted to me under oath that you have not paid rent for 16 months. Did you
I have
not?
admitted that I have, but that's not the rent that they're asking for, Your Honor. And that's not when they saying I defaulted, Your Honor.
Well, it's up to them that they're going to ask. Asking for lesser rent isn't necessarily illegal or not appropriate. That's their decision. Now, if they were asking for more rent than you very well would be responsible for, that'd be a different situation.
Okay, hold on one second. Let me grab my paperwork.
Okay. So this is what I'm gonna do. I understand that you've made certain federal allegations regarding UCC, but the contract that you said was never 1750 is 1750.
Wait,
So
whoa. Which
listen,
contract?
the contract I just shared with you says
Oh,
1750.
hold on. Let me go.
The
You
one
guys
that
still
you
pulled it up?
signed, give it a whole take.
In 2022? I didn't sign a contract for 1750 in 2022, Your Honor.
See, you don't seem to know what you're signing, which makes me concerned that you really don't know what you're arguing.
No, Your Honor, I do understand what I'm arguing. What I'm saying is the document that you're presenting is the one on the screen right now, correct? And can you go to the next? Can you go to the bottom page?
This is it. This is one page.
And that's saying, and the rent total on there is saying for 1750.
Yeah, let me see if I can. You don't see that right there in the second paragraph under position 2?
This is not a real document. That's impossible. The rent they send me now is for 1750, and the rent goes up every year. I would like to show proof that this is really a document that I signed and that this was not forged. Because the rent, I can show you proof.
It's electronically signed. What basis do you have?
Sent me a rental agreement for 1750. Hold on, let me check my files.
And here comes the finale. The tenant, identifying as a sovereign citizen, challenges the court's authority, claiming it has no jurisdiction. The judge, unfazed, fires back with biting sarcasm. There won't be any Article 3 courts involved. It's a perfect end. Logic meets delusion, and law wins again. If you enjoyed this wild ride through real courtroom chaos, make sure to like the video, subscribe to the channel, and we'll see you in the next one.
Your Honor, I did initially tell you I was not aware of how much the rent was at this current time because they hadn't been
Well, they did send you a demand of possession identified.
I did say that. I did clarify that to you originally. I said I was not aware of exactly. I said the last rent number that I remember signing with them was not 1750. Though
So
I did not remember signing that exact number.
You're saying your whole defense to this action of you being evicted is ultimately because they didn't respond to the accounting of your prior payments on an agreement that you have at ultimately become.
No, sir. What I'm saying is that my premise is, hold on, because it's going out. Hold on.
And I just want you to understand,
No, sir,
you didn't sign another rental agreement after March of 2023. And in fact, you had told me that you last paid in December of 2023, right? And then as a result, then it would just be
in December of 2023. Correct.
It would have just been continuing on a month-to-month basis. After March of 2023, you didn't sign a new lease, so you would just be continuing on a month-to-month basis.
That we would be continuing on a month-to-month basis? Because
you didn't sign a new lease, and it says that the lease terminated.
They never sent, but they never, okay, so this is the thing, and this is my whole premise, is not that they just didn't tell me. What I'm saying is that, Your Honor, is that they have not done any due diligence. They did not send me a new contract in 2023 whatsoever. I don't know if they had a staff change or something went on. They never sent the contract to get redone. They did none of their own due diligence for 2 years. Then they showed up saying that I owed them a certain amount of money after I had been paying. So I asked for them to show me that I owed them this money. They dropped all contact with me, Your Honor. And then a year later showed up saying, oh, you owe us $6,500. And so I'm going,
all right. That's a problem.
That's my problem.
Okay, so let me ask Mr. Brown, why did you guys not try to collect rent? Why did it take you so long to start this eviction proceeding?
It's a great question, and I don't have the answer for you. I do know that Mr. Stevenson has not paid. I've gone back on the records and he has not paid since that time that I stated. And on the ledger, and that's the amount that I'm going on right there, is that the last payment that we received was March 25th, 2023. That's the last payment that we've received.
Okay, and he's indicated that it was, well, that's not necessarily true because you indicated to me earlier that it was December 2020.
He did.
Yeah, December 2023. So I don't know how you can say the last record, but you're saying the last payment was December of 2023, which is also applicable with the fact that you were kept paying after the second lease was terminated. So you guys were at least continuing on your relationship then based upon you paying whatever amounts after March of 2023. So this is what I'm going to do. I'm going to give a writ of possession for the 13th. This is a completely appealable order. You can appeal what I've got going on, but I understand that you said you had an ability to potentially buy the property. But at this juncture, you've been in default and you've been in default for 16 months and they're actually asking for far less than what you would normally have to owe under the fact that you haven't paid. Now, your UCC arguments, they're still applicable. Like you said, they don't have jurisdiction here, but that doesn't necessarily mean that I have to stop everything I'm doing and not proceed here because the issue of possession as well as the monies that are owed are totally applicable. Your counterclaims effectively can be dismissed without prejudice because, again, I don't have the authority to rule on them anyway. But I don't think that based upon those arguments, that is going to ultimately prevent what's currently being presented, a default on rent, which is clearly just a rental agreement, as well as possession. I wanted to get resolved, Mr. Stevenson, but like I said, man, when you got 16 months past due and you can't show me contracts and you haven't shown me that you tried to buy the
asking for 16 months, Your Honor. They're asking for 4 months of rent.
And that's what they're going to get. They're not going to get 16 months.
Okay, well, I appreciate your honesty, Your Honor, and I understand that this is what your court how it goes. I got it.
Gotcha. Listen,
but
I
will be filing the appeal, and so we'll continue to dance.
You'll have 7 days from today, but bear with me. Let me
tomorrow,
and we will be amending.